The Labour Party governorship candidate for Imo State, Senator Achonu, is leading a protest to the headquarters of the Independent National Electoral Commission in Abuja. Now, the Labour Party governorship candidate is demanding for the certified true copies of the election result as conducted and announced by the electoral umpire INEC in Imo State. The protesters allege that the results announced by the commission is different from what the electoral umpire has on its server.
Our state collation agent duly asked INEC not to announce any result. That collation started very early that day, even while voting was going on. Uploading to the portal, to the IRF, started while even voting was taking place, was still ongoing. So how did that happen? That they should go to their back-end server and confirm the results they were about to announce, that they are not correct. So INEC refused to do that. That returning officer insisted, because you could see that he had an agenda. So we duly wrote to INEC asking them to review that election that they're not supposed to announce. They hurriedly announced that election, even before the 7 days that we allowed for review had passed. So INEC now, we wrote on Monday, we asked them, give us access to the same results that you claim that we lost, that you declared. Up till today, as we speak here, we have not received permission to collect the CTCs of that election. So we are asking that we are going to march into INEC now, since they don't even want to talk to us.
All right, this is the Labour Party demonstration in front of INEC. It's ongoing today. Here we have the National Youth Leader of Labour Party speaking. And right beside him is the Imo State LP governorship candidate, Achonu. They are here today along with their supporters to protect the outcome of Imo election. Just concluded the election.
I want to tell INEC that before the election, our campaign office was destroyed. Labour Party office was disintegrated. Then came and removed every signage on the party office. Is that democracy? Is that democracy? No. I want to repeat. Democracy. It's government of the people. By the people. If INEC commences the government of the people, this man there, clear for this man there. Who only government for the motion? Let me say that person. Nobody. Who will the government be leading? Nobody. We are here peacefully.
Now let's stay with the judiciary, because there are those, certainly many in the opposition, who reckon that unless the Nigerian judiciary is overhauled and urgently reformed, this country's entire legal system is at grave risk of implosion. So what will it take to make Nigeria's judiciary great again? Or is that golden age of celebrated judges now in the past? These days, as we load up on the fright fests that dominate the internet about the state of the institution of the judiciary, those questions are regularly asked as Nigerians assess the challenges and pressures that judges face today and wonder whether that period when they were at their peak has now been confined to memory. So will the Tinubu government produce a magic wand to fix Nigeria's judicial impasse? Is a big change coming, or is that a fool's paradise? Well, for more on this, I'm joined now in the studio by the senior advocate of Nigeria and untiring proponent of judicial reform, Jibrin Samuel Okutepa, who has written extensively and spoken volubly about Nigeria's election challenges. Thank you very much indeed for joining us.
Thank you, Charles, for again dragging me to this program.
And I think the word drag is appropriate.
Yes, because I seem to be tired of talking. I hope that after we say what we need to say, and we will say it here, those who have the capacity to give effect to it will do so.
Well, I think your words have a lot of weight because you are a respected senior advocate of Nigeria. And let's just start with that confusion over the appeals court judgment on the Kano election that you heard Toby Shoni, a judiciary editor, talking about there. What do you make of the discrepancies that have emerged? How much does that point a finger at the trustworthiness of the judicial system?
Maybe, Charles, the reason why this controversy is assuming a magnifying proportion is because of the times we find ourselves, where the rating for the judiciary had gone down very considerably in the eyes of Nigerians. Otherwise, this is not the first time that you will have some of these conflicting conclusions in the decisions of their lordships, particularly in election matters. I was personally a victim, so to speak, of this sometimes in 2016, when in the case of Senator Abraham Abubakar versus Senator Atai Aidoko Usman, there were 3 conflicting enrollment orders in which my clients had favorable orders, my clients had his election nullified, election order to be, a rerun order to be done, which eventually my clients was excluded by INEC. So you can see it in Abubakar versus Usman. It's reported in 2017, and I got pissed off relying on Senator Ucha versus Owen because of the grounds that led to that decision, which I felt were grounds that appropriately belonged to a pre-election matter and not within the domain of election petition tribunal. Relying on the previous decisions of the Supreme Court, I went to Supreme Court to say that the decisions of the Court of Appeal that had those conflicting enrollment orders, there were 3 actually, all signed by their lordships, by the presiding justice. Unfortunately, I became a victim of my adventure to have the Supreme Court listening to me, because I was admonished and told that by virtue of section 246 or so of the Constitution, appeal is senatorial matter terminates at the Court of Appeal, that I ought not to have come there. But there were previous decisions of the Supreme Court, Senator Ucha versus Owen, that the Supreme Court entertained appeal under the same 1999 Constitution. So I wouldn't want, because there's tension, and because of the tension in this country, I respect the institution of judiciary. I will not join the mob action. I would like to give the benefit of doubt to their lordships who gave the decisions.
Right.
And if that benefit is in their favor, and they can, with some considerable understanding from those of us who are members of this noble profession, then we need not to magnify it to give this appearance of impropriety.
Yeah, but nevertheless, I mean, I don't want to bang on about it, and we're going to move on in a minute, but the fact that those conflicting judgments were introduced into that certified
I read the judgment.
Yeah.
It is the concluding part of
that's the point
of the preside of his lordship that read the lead judgments that you will see
the mix-up.
The mix-up.
Yeah, but what I wanted to ask
when you read the body of the judgment,
right.
When you read the body of the judgment,
it seems to confirm what was said at the outset.
So the concluding part that are conflicting are those not things that when we have sovereignty and reasonability, if our judicial institutions were in those golden good old days that you want us to talk about, would it have made this kind of heavy news that everyone had become a lawyer? I concede that the judicial system as of today has a very dwindled image in the
Right.
sight of
I'm going to get
people.
to that in a minute, but I just want to sort this bit out so we can move on. In other words, what do you think happened there? I mean, because the reason...
It could be typographical error.
Yeah, but if it's a typographical error...
It could be human error.
Yeah, but the problem there is that the certified true copy is signed by the judges. Is the entire chain of command
in the example that I've given to you,
right?
The enroll order 2 was signed by the presiding justice. It's sometimes the pressure in reading what you think you have written,
right,
could be there. That's why in normal drafting techniques, it is not proper for you who have written a document to read it and produce file-proof documents.
You always want to have a second pair of eyes.
Person. Right. I'm wondering why their lordships who were members of the panel who read the leading judgment and concurred in the dismissal of the appeal did not detect it. So whichever,
and also whoever typed it as well.
Whichever is the case, it calls that the judicial arm of government must be careful in this volatile society of ours.
Well, let's move on from there, because I wanted to get to the fact that you represented P2B and the Labour Party during their legal challenge at the tribunal and the Supreme Court. What was it like trying to gather the evidence you needed to support your case and having to deal with INEC in that regard?
You see, it's an unfortunate situation that the judiciary, that is the arm of government that have been given onerous responsibility and grievous responsibility of stabilizing democracy, appears with respect that some of the decisions have created more roadblocks for those who lost election to prove the allegations in the petition. And I must commend Parliament, because following the outcry of Nigerians that the election petitions are difficult to prove, Parliament introduced Section 137 of the Electoral Act to say that where there is obvious non-compliance in the face of the documents, then you can look at the document and make pronouncements. But the insistence of some of our courts that you must call host of witnesses, including polling unit by polling unit agents of political parties, for me had put a spanner in the growth and development of democracy in Nigeria. And I have written that if our judiciary can take judicial notice of who goes to television station and who address the press after court proceedings and maybe angry or upset for such a conduct, they must also, in the same vein, take judicial notice of the conduct of Nigerian politicians. For instance, how many political parties do we have in Nigeria? There are more than 18. And now you are expecting that party agents have a carbonized copies of the result sheets. How legible are those carbonized sheets of the result sheets? Now, Parliament in their wisdom said, we are going to use BVAS machine, and that once elections are conducted at a polling unit, the BVAS machine is used to scan and then uploaded on IREF. Then we came to our judiciary, who we trusted will now hold INEC responsible for the INEC accountable and responsible for the innovations introduced in its own manner, that BVAS becomes sacrosanct in determining the credibility and the integrity of election. For the court to say that BVAS plays no significant role until you have gone through the processes and that you can manually collate results. For me, those decisions have taken Nigerian democracy from 21st century to 13th century or Stone Age, where we no longer recognize the importance of technology. So for me, proving election petition, I was in the legal team of P2B, and no doubt, in that legal team, we were able, for instance, to get certified true copies of over 18,000 blood images uploaded on IREF. There were subpoena issues on INEC for documents to be produced. INEC did not produce these documents. At a point in time, it got to a level that an institution that was in disobedience to series of court orders, mark you, subpoena is are orders of court. Institution that was not respecting a court order got a pat on the back by no single sentence, either in the Court of Appeal or in the Supreme Court, condemning that attitude. Indeed, the referee became more of an attack in the field of litigation than even those who were recruited to engage in the attack. There were a series of objections coming from INEC, which ought not to be. So then you come to the argument that you must front load a subpoena witness statement along with the petition. I do not think that is possible. Are we saying that if I needed a document from INEC and I must then get court order, front load INEC statement, who will sign it? Will INEC staff sign it? So we must go back.
Right. So there were a lot of complications.
There were a lot
and
of
challenges for you,
and roadblocks,
and that made it
put in
difficult.
the way of petitioners.
Right. That made it difficult for you to effectively prove your case.
Not only making it difficult, it makes it so difficult and uphill task
impossible
that it was, to use the language of one of my famous profession, it was impossible. It was impossible. It could not, because the document that we needed to have, indeed you may recall that even the demand for payments of CTC of documents became so outrageous. We reported it. But that the decision of the court is the decision of court. But Nigerians,
when you say demand for payment, what do you mean?
Charles, if truth be told, Nigerians will need to interrogate the process of getting certified true copies of documents. Are they free? In
other words, you were being asked for inducements, because payment for a document is different from someone saying under the table, you must induce,
it's difficult to
give me an inducement for me to give you this document.
Inducement may not be asked directly, but there are circumstances that suggest that if you don't
that is the motive,
you can't get.
Right.
So do we have remedies for public officials who have responsibility to do what they needed to do, not to engage in commercial ventures in the performance of their functions?
And this was coming from INEC rather than from the judiciary.
Well, look, judiciary does not give documents. Judiciary issues order.
No, I mean the demand for inducements that you're
I wouldn't use the word inducement. It's too high.
Right.
I mean, the hard is something. But it was a system that was difficult for you to overcome.
Right.
Because if you cannot get, you will not get.
Right. So in that context, what reforms would you recommend, both for the judiciary and for INEC? And do you see INEC as independent?
How can? There is no independent institution in Nigeria. In practical reality, anybody who tells you that INEC is independent would have, that's a story that you can tell to infants in Tale by Moonlight. In practical reality, no. Because there are some things that happens that shouldn't happen for an institution that is independent. when we talk about independence of institution, not in Nigeria, because there is no loyalty to the Federal Republic of Nigeria by those who have responsibility to hold to give loyalty to Nigeria. The loyalty is either those in power or those who have the capacity to detect the tune of what you are supposed to do, popularly come to be regarded in Nigeria now as the cabals. There are cabals in our electoral jurisprudence, there are cabals in so many of our institutions that they have no respect for what is called democracy. Because democracy in Nigeria, for instance, is not a product of the sovereignty of the people. If it were so, we would have not had what we are having. INEC is more, and when I say INEC, I mean the staff, some of the staff, not all, and only infinitesimal number of them, because the chairman of INEC, for instance, cannot be everywhere in the polling unit. Who did you recruit to go to the polling unit for purposes of conducting election? Do they obey the rules and regulations churned out by INEC itself? Are we holding them accountable? Who did? Because if you recruit a stupid person to perform a job for you, then he performed the job stupidly, you are held responsible for it. So that's one. Now, when you talk about reform, I think the reform that we need, because judiciary is an important arm of government, and it is only arm of government that is an exclusive preserve of the members of the noble profession of law, the legal profession. Because our qualification is not just ordinary school certificate or its equivalent. We went to university, went to law school, we had code of conduct. There is, I will advocate for now, that both the legal both the member of the bar and the bench should have character reform. We must reform our character. We must have a defined goal. Do we want justice in Nigeria, or we want judgment devoid of justice? Because when you have the misfortunes to prosecute election petition, the attitude of some colleagues in the courtroom leave much to be desired. Secondly, I think that our recruitment process is faulty. We recruit people not on the basis of, in some cases, on the basis of what they know or their strength of character, but on the basis of connection. And for me, when appointment to the bench has become hereditary in terms of religious hereditary, biological hereditary, social hereditary, political affinity, then the judiciary will face a calamitous consequences, just like we are facing now. So for us to get it right and go back to the golden age, the lobbying to be made judicial officers by political class and the power that be must stop. Let us have men and women of strong character who cannot, because of a pot of porridge, or because of the color of naira, or because of the color of dollar, or because of the air-conditioned cushion home somewhere, or the flight ticket to go holiday in cozy environment in overseas, who will not sell their conscience and give questionable judgments that will undermine democracy. Because Nigerians are becoming very sophisticated, and let nobody tells me that the feelings of Nigerians on the street does not matter. We must be very careful. And I have said in one of the papers that I delivered on the 16th of this month, that if we are not careful, the first victims of uprising and anger and upset of Nigerians will be members of the legal profession. And in doing so, they will not discriminate between those of us who do not belong to the class of those who pollute the stream of justice and those who have taken it upon themselves and wear the garment as a conduit for which the stream of justice is polluted. And let me say this: justice is rooted in confidence. And when right-thinking members of the society go away saying that justice has been compromised, then that society is heading to a calamitous end.